Thanks.
Who was sitting with next week? How do you say his name? Kieran. Kieran. I'm not sure what you were saying. Yeah. Do you know my job? Just sit in court next week. Yeah, I know that. But if they don't, then what?
Court rise.
Yes, Mr. Beale.
Thank you. Could I just make a couple of points that I foreshadowed shortly before the short adjournment? Firstly, we are dealing here, of course, with further and better particulars that were directed by Judge Brooks on the 10th of May 2017. And we do say it's important when considering the terms of the further and better particulars to recognise that they were directed by the tribunal in order to clarify and narrow the issues between the parties. So the reason why any party is ever told to clarify its case is so that the tribunal doesn't have to waste time dealing with things that aren't relevant. If it's common ground, there's no need to have all the evidence and fact going to it. So we do say it's important in that context to see the FBPs for what they are. It was also put to me that this hadn't been raised before the First Tier Tribunal. The irony here, of course, is that the express reference to it in the oral submissions is in a transcript, the addition of which I've objected to. So the expression voiced by my own petard. But for your note, should you decide in due course to look at the documents Muller and friends seeking to introduce, it's De Bene Essay. It's transcript A5, page 132 to 133. Now, what then happened was, because the closing submissions didn't fully finish on day 5 of the hearing, my learned friend Mr. McGurk, who, for reasons I'm afraid I don't fully understand, had gone first in his submissions, then didn't finish his reply submission, so he asked for permission to reply in writing. He then filed written submissions, and we filed submissions shortly and briefly in response to that. Those submissions went on a different issue, which was whether or not control or possession had been dispensed with by my client. The pleading point, if I can put it that, is dealt with orally by Mr. Howard of Counsel at pages 132 to 133 of day 5 of the transcript. So in answer to my own specific question, that's where it is. The point was developed much more fully, I accept, at upper tribunal stage. And what I propose to do is to take you to the relevant parts of that as and when I'm going through paragraphs where the upper tribunal deals specifically with the way the case is put. Now, that then, in a sense, is how the pleadings were dealt with. In terms of the law, could I briefly turn back to Article 14, which is in Bundle of Authorities 1, Bundle of Authorities tab 1, sorry, internal page 22. Article 14, subparagraph 1 says the paradigm of the supply of goods is the transfer of the right to dispose of tangible property as owner. So what you're doing is giving somebody else the ability to treat those goods as if they were their own. And then 14.2, subparagraph B, also has of situations in which the actual handing over of the goods pursuant to a contract for the sale of goods on deferred terms, providing, etc., in the normal course of events for full ownership to pass at a later stage. So that refers to the concept of the actual handing over of the goods. Now, part of the difficulty here, of course, is that everyone accepts that there has been a sale by my client, but the parties differ as to what the nature of that sale is. But come what may, the fact is, we say, and the fact was accepted by way of a concession by the commissioners, that the goods had physically been delivered and handed over to, for want of a better expression, the so-called smugglers, at a point prior to their arrival in the United Kingdom. And that, we say, was the effect of the FBPs. In terms of the UK law, that can be found in paragraph 1 of Schedule 4 to the VAT Act. That's behind Bundle of Authorities tab 3. Doesn't have internal pagination, I'm afraid, or if your lordship have obtained the paginated bundle, it's at page 53. But failing that, it's about 6 pages in.
So it's section...
Tab 3,
Yep.
and if one turns forward 6 pages,
Yeah.
one ends up with a heading at the top saying paragraph 1, UKST 1994, chapter 23, schedule 4, paragraph
Yep.
1.
Oh, schedule, sorry.
Schedule. So,
Schedule 4, yes.
Schedule 4, paragraph 1,
Yes.
subparagraph 1 says any transfer of the whole property and goods is a supply of goods. Then it makes some caveats which don't apply. Subparagraph 1, subparagraph 2 of paragraph 1 says if the possession of goods is transferred under an agreement for the sale of goods, and then under other agreements, it is then in either case a supply of the goods.
Right.
And 2b deals with the retention of title point, just so I can get it out of the way. Under agreements which expressly contemplate that the property also will pass at some time in the future, by or ascertainable from the agreements, but in any case not later than the date when the goods are fully paid for. So even if there were somehow a retention of full property in the goods until payment, that is still a supply of goods once possession is transferred. That then is both the domestic and the EU approach to supply of goods. It's not coterminous with a legally binding contract of sale. And for your note, the Oliver decision I referred to is behind tab 13 in this bundle. If we've just turned that up very briefly at page 73 of the report, I think it's sufficient for my purposes to go to the head note and the holding. I've summarised the nature of the dispute. Supply for the purpose of the Finance Act meant the passing of possession in goods pursuant to an agreement whereunder the supplier agreed to part and the recipient agreed to take. Possession in that context meant the control over the goods in the sense of having the immediate facility for their use. The reasoning of Mr. Justice Griffiths to that effect is dealt with at page 75, and it covers also the well-known Carlton Club case dealing with supplies of drinks to members of a club, which was also a supply even though there was no direct contractual entitlement to the supply, and the remuneration was phrased as repayment of sums due to other club members. Those are the legal points I wish to address. What I propose to do, unless your lordships or lordships have any further questions for me, is move on to the Upper Tribunal decision itself, which is the decision that is under appeal directly in this case. That is behind tab 7 of the core bundle. And the learned judges of the tribunal set out the background under an introductory section, page 57. And in particular, halfway down paragraph 2, they make the point that the FTT rejected a Ward's case that the deposits were payments for sales of alcohol from bonded warehouses, backdrop against which the assessments arose was HMRC's views, having traced the...
Sorry, where are you reading?
I'm sorry, this is from about 6 lines down paragraph 2
Paragraph
on
2.
page 57.
Yes, sorry,
Slightly
I've got it now.
convoluted sentence, but the backdrop against which the assessments arose was HMRC's view, having traced the relevant supply chain, that the goods sold entered the UK as a result of diversion fraud. As such fraud entails goods held in duty suspension purportedly being released for consumption in the country where they attract a lower duty rate, for instance France, with an obfuscatory paper trail. In fact, the goods are smuggled to the UK where they're typically sold immediately for cash. And that was the relevant factual background, the premise behind the relevant appeal. And then the 2 grounds of appeal are identified specifically in paragraph 3. Now, this was never a case, we say, in which it had been suggested that ADL had in effect sold the goods directly to customers in the UK and then pocketed the money. That was, we say, necessarily implied by the approach HMRC took to saying you have received consideration in the UK and that is for a UK supply of goods. However, those assessments, as you've seen, were in fact based solely on the location of the money payments, which was not, we say, the relevant issue. At paragraph 29 to 30, page 62, the Upper Tribunal direct themselves by reference to the Brady test. And we say respectfully that what that didn't take into account was the fact that the concessions HMRC had made quite necessarily narrowed the ambit of the issues between the parties. So what was left was not pure Brady, if I can put it that way, but Brady through the prism of facts which were no longer an issue between the parties. At 40 to 41, at page 65 and 66, there is set out the submissions that Mr. Howell of Council made on behalf of the appellant below, which was that reliance on Brady was misconceived. It then says 3 lines from the bottom, page 65. Mr. Howell developed his point in oral submissions as follows. He accepts that Brady means that where the taxpayer's version of events is rejected, this does not mean a finding of fraud is made, because there is an indeterminate third category under which, in effect, the taxpayer's version of events is simply not proved. However, he distinguishes award situation from this third category, given the clear legal position that award would have to be in possession and control of the goods for it to have made a supply for VAT purposes in the UK. The FTT decision in upholding the assessment is necessarily a finding that award brought the goods back to the UK and retained possession and control. That, the award says, goes beyond the Brady uncertainty of an indeterminate third category of not proven. The Upper Tribunal then rejected those arguments. They agreed with HMRC that award's suggested analysis impermissibly reversed the burden of proof. Now, just pausing there, what of course the Tribunal didn't take into account was the nature and extent of the concessions which HMRC had already made. If a matter is conceded by a litigant before a court, it necessarily follows that it doesn't have to be proved. And the practical consequences of not following that proposition would be significant for both HMRC and taxpayers in litigation up and down the country, because it would discourage anyone from ever making any concession as to what was a perfectly obvious point, for fear of that concession not holding water as and when the matter comes to be written up for judgment. And so it would give actually each litigant free rein to go back on something that they had said on the basis that, well, it would certainly give the commissioners free rein to go back on what had been said behind the general penumbra of the Brady principle, in a way that would mean that no tribunal could sensibly ever confine HMRC's case to a set of certain propositions which were in fact not contested and were therefore accepted. And that would have very serious ramifications for tax litigation in this jurisdiction. The short point is Brady retains its full force and effect in circumstances where the commissioners simply are unable to understand what has happened. VAT is a self-assessing tax. One can see why that has a measure of force in certain circumstances. But the truth is, if in fact they have made steps to investigate what's going on the back of those investigations, they make averments as to what the position is, and they make concessions as to what the position is vis-à-vis a particular litigant, then in my respectful submission, that litigant ought to be entitled to rely upon those concessions and not find that those concessions are pulled from underneath the rug of the litigation by a cross-reference back to an assertion of the Brady principle as an overarching principle.
But isn't this all a bit artificial? Because after all, the person who really knows what happened was your client.
Well, my lady, it's precisely because we don't know what's happened to the goods once we no longer have possession or control of them that we're as blind as HMRC as to the mechanics of the fraud. The mechanics of the fraud would be known to those people who were parties to the fraud, or who knew or should have known that a fraud was taking place. And of course that's the express position that the commissioners did not adopt. Well, they adopted it initially and then rode back from that suggestion that we were a knowing party to the fraud. So if the position is your client was so intimately bound up in this that it knew or ought to have known what was going on, then of course that is a Kittle allegation of fraud and non-participation. That is expressly what HMRC have said they're not doing here. Now, paragraph 42, the Upper Tribunal dealt with the application of Brady to the the VAT context. By citing the FTT's decision and its cross-reference to the Khan Greyhound Dry Cleaners decision of Lord Justice Carnwath in the Court of Appeal in 2006. I'll come back to that in a moment, if I may, and repeat the marker that I put down. But at face value, the Brady proposition can be applied in a VAT context as matters stand, taking the observations of Lord Justice Carnwath as persuasive and recognising that it's not the appropriate place now to suggest why they're wrong. We then come on to paragraphs 49 and 50, which I invited the court to read earlier, so I needn't dwell on. Suffice to say, if I can make the forensically obvious point, that there is no reference there to any of the further and better particulars given by the commissioners in this case, and which I no doubt belaboured before lunch. Now, we do have a concern, and you've seen the concern expressed, that the strict division between pleading a fraud and proving a fraud and simply relying on Brady does cause consternation quite often in litigation. And where you have a situation in which HMRC start off pleading fraud, change their mind and say, oh, actually, we're not pleading fraud at all. We're not suggesting you had any involvement whatsoever. But by the way, we think your entire transactions are smoke and mirrors as part of an inward diversion fraud, which we don't say you were party to. That dividing line becomes really quite thin. And of course, had the commissioners gone further and said your specific transactions with your French customers were sham, then of course the hitch and stone approach, classic approach of the person who alleges sham having to prove it, plead and prove it, would have applied. But of course, again, they narrowly rode back from going that far. And what they said was, we don't believe that these transactions are genuine transactions, and it's for you to tell us that they were. But I'm simply outlining at this stage, it's a pretty thin dividing line in many cases in practice between not advancing a case and advancing a case of fraud by the back door. So that, again, I needn't belabor that point now. Paragraph 71, the Upper Tribunal again reverts back to the way that HMRC's pleaded case was put. But again, with respect, with no reference back to the FBPs and the concessions that had been made. And indeed, there is no reference whatsoever in this judgment, this decision, to any of those concessions in their terms. The findings in relation to possession at paragraph 80, stating that we are left in no doubt that it would be open to an FTT in such circumstances to reach the conclusion that possession and control of the goods was not lost in France. It's top first sentence of paragraph 80 at page 76. That necessarily proceeds in apparent ignorance of the fact that HMRC had recognised that the goods in question had been delivered cross-border by somebody who was not my client. So they had been delivered, conveyed via a haulier to persons unknown by persons unknown. That person, it being said, was either the supplier or the customer of the goods, but not us. And so you simply do not have there any recognition that that was HMRC's case, and that possession can just as easily be lost through somebody else taking the goods and assuming control over them and the right to dispose of them at their will, as it can by a formal contract of sale. And that's vouchsafed by the case law I've taken you to of Oliver, and it's vouchsafed by the actual terms of the legislation that I referred to a moment ago. So when, at paragraph 81, the Upper Tribunal comes on to consider the question of possession and control, it does so solely on the basis that the financial transaction documents were not evidence of genuine transactions in bond. It doesn't consider the position, assuming that's right, and that therefore you can't point to a contract of sale in bond with the goods being transferred to identified French customers, whether nonetheless the goods had, the possession of the goods was found in the hands of, I'm going to use the term in inverted commas, the smugglers, and the smugglers had then delivered the goods to the UK. Again, I'm using that expression smugness, but we simply don't know what happened. We're simply accepting that HMRC have done their homework looking at the supply chains and think that there was a smuggling operation in place, and we're not in a position to gainsay that. Paragraph 83, we again see a reference to a finding that had the FTT concluded that the documentary evidence showed that possession and control had been lost, it would have been an irrational conclusion. Now again, that doesn't deal with the concession made by the commissioners in the course of the...
No, but this was all, I mean, I'm trying to grasp this, but in paragraph 82, the tribunal says, the initial premise of the ground that the FTDs were not challenged is not made out.
Yes.
So, I mean, that's a different point from the one that you're putting before us.
So the express ground was articulated as being there was a failure to take into account the financial transaction documents, which showed that there had been a sale in bond and that therefore possession and control had been lost by the time that the goods were delivered to the UK. That was the way the argument was run.
And alternatively, as in 81, that there was a bare transfer of possession and control, irrespective of whether there was a sale.
Yes.
As demonstrated by the FTDs.
Well, in part as demonstrated by the FTD.
As part, I see.
In fact, what we will see is that an alternative argument was run that even if you couldn't rely on the FTTs for whatever reason, as a matter of the concessions that had been made by HMRC, there had necessarily been a transfer of possession.
Okay.
And it's that argument which, in fact, the Upper Tribunal decides expressly not to deal with. So at 84, it says, in view of our conclusion, it is not necessary for us to decide whether a award is correct. That on the basis of Oliver, as a matter of law, a taxpayer can never make a supply of goods for VAT purposes if it has divested itself of possession and control of those goods. That, in a nutshell, is the argument that I've been articulating this morning, on the basis that it was conceded by HMRC that we didn't have the goods at the important point of their dispatch cross-border from France to the UK. And the learned judge decided not to deal with that argument because he said it didn't matter because of his findings on the financial transaction documents. And again, with respect, that simply doesn't follow. Because one can have a situation in which you accept that the explanation that's been given by the taxpayer is not correct. I think a cock and bull story was the expression used to be.
It's a well-known technical term in these type of cases.
You'll understand why I don't adopt that. But if I can say it's accepted, we obviously accept that our client's version was. No, levity aside, we accept it wasn't accepted. But that doesn't mean that the position wasn't, as the Commission has rightly accepted, that the goods in question had been taken, for want of a better expression, by other people, and possession of and control had been assumed by other people, and those smugglers, by virtue of the very act of smuggling them into the UK, de facto, not de jure, a right to dispose of the goods as they saw fit as owners. Now, it's telling, we say with respect, that the Upper Tribunal simply decided not to deal with that point. And we can dig into a little bit as to how that decision was reached. And to do so, I need to turn, please, first, in the supplemental bundle, to tab 17.
Can I just let me read 84 to myself for a moment, I'm sorry. Yes, I see. Yes, I see. And they say, well, we don't have to deal with it because there wasn't a divestment. I mean, a divestment of possession and control has not been established. And you say, well, they should have had regard to what you say is the concession by HMRC that actually does establish it for the purposes of this case.
Exactly so.
Yes.
And one sees the way this was put in writing in a skeleton before the Upper Tribunal. That's tab 17.
So, Mr. Beale, sorry, before we leave the Upper Tribunal's decision, I think before lunch you were saying that you hadn't really focused on the decision of the FTT because the Upper Tribunal had remade it. But if you look at paragraph 92, you will see that the Upper Tribunal adopted in its entirety the FTT's decision. So it is incorporated by reference in the Upper Tribunal's decision with the additional reasons at 76 to 79.
Yes, my lady. But the FTT didn't deal either with the concessions.
Yeah, okay.
So I accept that the concessions point was put more lightly before the FTT, but the FTT's decision was in fact set aside and remade. The point was certainly before the Upper Tribunal, and are in clear and unvarnished terms, and our appeal is against the Upper Tribunal's decision.
Okay.
So if I could turn please to Supplemental Bundle, tab 17, page 227. You could pick it up please at paragraph 38. The first part of that paragraph is dealing with the point that isn't open to me because I was refused permission on it, so I shan't.
So we're at page 227.
227. I hope.
Thank you. And this is the...
This is our skeleton argument.
Right.
Before the Upper Tribunal.
Right.
So the first part is dealing with the veracity or otherwise of the FTDs, and it was being said that the case that they were invalid hadn't been properly put. That was one of our grounds of appeal for which permission hasn't been given, so I'm not going to deal with that. But at the end of that paragraph, it says this: further, the basis of the respondent's own case, that the appellant was not in direct or indirect possession or control of the goods when they were smuggled into the UK, is incompatible with their argument that the appellant failed sufficiently to prove this aspect. The FTT could not have upheld the assessments in the circumstances, and the Upper Tribunal ought to allow the appeal. So that was the way it was put specifically in writing. We do permissibly have in evidence, happily, the transcript of the Upper Tribunal hearing, and I will, if I may, just highlight one or two of the salient references to this in oral submissions. This is at Core Bundle tab 8. If we could start please at page 82. Sorry, I think it starts technically at the bottom of page 81.
Just let's get that. Bottom of 81.
Bottom of 81. This is a submission from Mr. Howard of Counsel on behalf of my client. The case has always been pleaded on the basis that we were not in control. Sorry, we were not transporters of the good back to the UK or involved in any way whatsoever in their transport back to the UK. And that is the way the case has been put. And we will come on to that. You've seen our supplemental skeleton argument on that point. And then at line 21 to 24, it said, what I can say is absolutely unequivocal. The case that was put was that we had no involvement whatsoever in the transport and the diversion of the goods to the transportation of the goods back to the UK. No involvement whatsoever. And now we have a completely refreshed attack on that basis. Then at page 95, it said at the bottom, line 31, so we put our argument on the basis of the case included below, in that there was no removal and we were not involved. Our supply in France was not a supply which involved a removal to the UK. So we fell within this section 7, the VAT Act. The point was accepted by HMRC that there was no removal to the UK, but our supply did not. That did not involve removal to the UK. So if you go down to subsection 4, these are the provisions and so on. So the submission was being developed by reference to the Commissioner's pleading. Then at page 97, would the court please read lines 10 through to 22? simply wasn't within the parameters of what either side was suggesting, that we had somehow removed the goods ourselves, physically dispatched them to the UK. Then at page 119, there's a lengthy section that deals expressly with the pleading point. Could the court please read lines 9 through to 32? If I can try and encapsulate that in my own words, essentially what's being said is, well, look, it's never been suggested that we were involved in the physical delivery of the goods. Somebody else was taking delivery of the goods and supplying them. That's necessarily part of the fraud. If it had been suggested that we were intimately bound up in the transport of the goods, we would have been part and parcel of the fraud. And that's exactly what's not being said against us. What Mr. Howard then did, much like I have with your Lordship and your Ladyship today, is to go through the FBPs with some care. We can see that at page 170 to 171. And again, if I could please invite you to read line 30.
Page, sorry?
Page 170. 170, line 27.
170. This must be his replies as well.
No, this is still Mr. Howard, I think.
I thought I'd seen Mr. Okay.
I think Mr. McGurk interjected once.
He interjected. It was quite a long interjection.
So at 170.
Interjection. 170.
170, page 27, line 27, starting with Mr. Howard. It is what HMRC's pleaded case was, and if the court would be kind enough, please, to go through to Mr. McGurk's interjection at line 27.
So you want to start at line 27, did you say?
Line 27, 170 through to line 27.
Okay.
171.
Yeah, I see. Sorry, can I just trying to see, because he begins, it is what HMRC's pleaded case was. So what's he talking about there?
He's talking here about possession and control.
Is he?
And so
where do I?
One sees Judge Scott's, they should have considered whether the French transactional documents on their own demonstrated on the balance of probabilities you've divested yourself of necessary possession and control. So one of the strands of arguments was, if you had put to my witness properly that the FTDs were invalid, they would have given you more satisfactory answers and shown that they were genuine. That was not really contested, therefore you have to treat them as genuine. Answer, well, that goes to the question of whether or not they divested yourself of necessary possession and control. And is that your case? And the answer is, well, it's also HMRC's pleaded case.
Okay. Yeah.
Now, the approach of the Upper Tribunal to this argument was.
But is he here dealing with the further and better particulars as they relate to how the goods, as it were, got across the channel?
Who was responsible for the dispatch of the goods from France to the UK?
See.
Because if goods are dispatched from France to the UK by somebody other than us, we say it necessarily follows that you've lost possession and control over the goods.
I thought this was looking at those. I know we looked at these particulars, the ones about who made the supplies in the UK, and the answer we don't know.
So those particulars,
rather than those other particulars, which I understand to be the linchpin of your argument today.
so the particulars that are being referred to are
Yeah.
the ones that I took you through this morning.
Well, you took us through several, but if we just remind us, I just want to be clear which they're referring to here.
There's only one set.
I know there's one sentence. Which particular paragraph? Sorry.
That isn't clear, but by reference.
Well, I thought it was reasonably clear. That's why I'm just raising it.
I see. Well, in context, it must necessarily be. I mean, they haven't said this is response X, and unfortunately, the response numbers keep on reverting back to 1 and 2.
Here we are. They're tab 10, aren't they?
I think they're in the supplemental one. Tab 10, yes. I think this goes to the ones at page 125 to 126.
Right, okay, let's have a look. Well, no, I'm not sure they... Oh, well, I didn't think it did, actually. I thought it was... It read to me as if it was referring to... hold on. I thought it was referring, for example, to page 120. I may be wrong. So paragraph 2. No, that's, I think maybe that's at line 3 on page 171. So we've looked at paragraph 2, which says quite clearly HMRC does not know the identity of who made the taxable supplies in the UK. So that may be request 2.
That's reply to request 2, actually.
Yes. Then now turn over the page and look at the response at 1, in particular the case of last by, which is goods that the appellant contends were supplied to its French cash account with the subject of taxable supply, the consideration for which was paid. Then it talks so. Then we go turn over to 148, and at response 2 at the top, HMRC cannot and does not need to identify the persons who made the taxable supply in the UK. That's
And then I thought he went on to 150.
150. I'm just trying to work it through. Yes, I see. I see. So where's that? Where do we see that? HMRC's case is that the appellant's goods were only sold for consideration. Where do we see that?
The trouble is,
This is actually on page 123, isn't it? It's at the top of page 123. That's quoting that. So page 150 is what we have as 123, I think.
yes, and then he moves on to 152.
So this, he says, is the high watermark of HMRC's legal, and it's nonsense. This does not ground our... But all I'm saying, okay, well, the part you asked us to read, I think we can see does not deal with what we have got at 125 and 126.
So that would equate with page 152, which is line 26, which is the point at which Mr. McGurk interjects.
So he wanted to go on to 152, so... Yes, right. And so he's now going to be dealing with what we've got.
Yes.
At 125, right? Okay.
Mr. Howard goes on to make a series of points. It's fair to say he's getting a degree of resistance to the submission that's being made.
So where does he deal with what we have got on 125 and 126?
Well, it becomes, I mean, it develops over the course of the next few pages. I mean, I was going specifically there because there were express references to the FBPs.
Yes, but they're not to the
But they're
bits
not
that
to
you're
125
particularly
and
concerned with, and
126.
I had understood they were.
So
That's
he
that's
then
why
goes
I
on
was...
to develop the case by reference to possession and control in the context of the FBPs more generally. And for example, at the bottom of 172, Judge Scott says this is a further embedded particular in relation to a particular subparagraph of HMRC's statement of case, continuing payments and so on. And Mr. Howe said, no, I'll come back to that. And Mr. Howard said at line 23, when you read this and when you read the particulars together and the allegations that are being made, this is in essence how HMRC, this is the only positive statement of how, and I think what he's saying is how the goods have been transferred from France to the UK. And it clarifies the point of how we got to be liable.
Well, you're going to have to do slightly better than that for me, because I want to see where he says that.
I'd understood him to be referring generally to the FBPs, and he's saying essentially that we weren't responsible for...
Well, I think maybe he may pick it up at the bottom of page 173.
HMRC does not contend French cash and carries were actually an agent of the applicant for the purposes of effecting or diversion. Yes, my Lord's absolutely right. That's a better reference.
Perhaps the...
Does not need to allege that the appellants let French cash and carries act as agents as regards. There's nothing on HMRC's case which is consistent with us controlling the goods in the UK. It's not been put and it's never been put that we control the goods in the UK. And he then says at line 13 to 15, effectively, that that's a specific allegation that we put the goods, that we smuggled the goods back to the UK. What I understood counsel to be doing was highlighting the tension I've identified between an allegation that we had nothing to do with the wrongdoing and weren't involved in the fraud, or concession fraud, and a suggestion that we had somehow supplied the goods directly to the UK, which is impossible to square if, as is the case, HMRC have conceded that the transfer, the dispatch of the goods was conducted by persons other than us.
Yes, but all I'm saying is that at the moment I can see that Mr. Howard was addressing that at 173 to 174, but I don't see him addressing it earlier.
Don't see, I'm sorry, my Lord.
I don't see him addressing that earlier.
No, I think my Lord's absolutely right. I failed to track through the page references and rather assumed what the nature of the submission was being developed, because the overall gist of the submission at this stage is that we've lost possession and control because the commissioners have accepted that somebody else smuggled the goods. That, in a nutshell, is the case that's being made.
This, incidentally, I can see from lines 16 and 17, this is part of Mr. Howard's reply on page 174.
Yes, so what had happened is Mr. McGurk had gone first. I'm sorry, I thought you said this was Mr. McGurk's reply.
No. The point is this Mr. Howard's reply? And you thought, no, it was part of his opening submissions.
Oh, no,
because I was slightly surprised he'd be dealing with it in his reply, and it transpires the Upper Tribunal was as well. Because that's what they say at lines 16 and 17.
Yes. I'm sorry, I'd misunderstood. I thought you were saying it was during Mr. McGurk's submissions.
No. So this is brought in by way of the reply before the Upper Tribunal.
It had been developed in the skeleton argument, and I've taken you to passages where the FBPs have been cited earlier in opening submissions by Mr. Howard. So what we see is correct to say at paragraph, at lines 25 through to 29 of Judge Scott's decision, is he says we need to determine the fate of your appeal. That's what we have to decide. We do not have to decide as part of what HMRC's case may have been at any particular stage, or what might have flowed from that in terms of what is implied. So we have let you have your say on that, but I'm becoming increasingly concerned it's not going to be what we have to decide. Now, of course, that explains, with respect, why we don't find any mention of the further embedded particulars and the clarification and concessions made by the commissioners in relation to their case in the Upper Tribunal's decision. So Judge Scott had concluded that this didn't go to the issue he had to decide, notwithstanding the arguments that I've identified both in writing and oral that were presented throughout Mr. Howard's submissions. Turning back to the Upper Tribunal's decision, tab 7 of the core bundle, I could just finish off the analysis, please. Picking it up at paragraph 88, page 77. Bundle. We see paragraph 88, 89 deal with the insufficiency of reasons that they found. They then say in paragraph 90, but we can go on and remake it. And in doing so, paragraph 91, they say, as explained in dealing with ground 1, the FTT was fully entitled on the basis of the evidence before it to reach the view implicit in its conclusion that possession and control of the goods was not divested in France. Well, the greatest respect, that then doesn't deal with the legal argument that the Upper Tribunal had already indicated it wasn't going to deal with it before, which was that it necessarily followed from the Commissioner's concessions that there had already been a divesting of the goods, possession of the goods in France, because somebody else was, in inverted commas, smuggling the goods into the UK.
But sorry, I come back to the point that I think I had understood 84 to be referring back to the premise, which was the non-FTDs.
But it was dealing with possession and control.
Yes.
In the context of the FTDs.
Yes.
And that was the primary source of the challenge. But the challenge had also involved fallback position as articulated in the paragraphs I've taken you to. That it was also our case that the reason why the FTDs were supported on the possession and control point was also because that was an inherent part of the Commissioner's case. So the Commissioners accepted that the goods had been, possession of the goods had been transferred to other people when they necessarily recognised that we weren't part of the dispatch of the goods from France to the UK. And that was how Mr. Howard had put it at various places. And that was the long section of the transcript I invited the court to read. Is, by the way, we also say it's the respondent's case that this took place in this way, and that fortifies our conclusion that we no longer had possession of control of the goods at the time of their removal. Mm. Now, the respondent's notice from the commissioners now, with respect, seeks to row back from those concessions that were clearly made. But rather than getting my retaliation in first, I'll wait and see what Mr.
I couldn't, I mean, I was going to raise this with Mr. McGurk. I couldn't quite understand this document, which is headed Respondent's Notice. It's read to me like a skeleton argument. Are you referring to the document in tab 1 of the core bundle? Yes, I mean, there isn't a Respondent's Notice, actually. Assume that this is a skeleton argument. We haven't got there is no document. I mean, we know what a Respondent's Notice looks like, but we haven't seen one. So I've simply treated it as their skeleton argument. But either way, you say it rows back, seeks to row back.
Yes. Okay. I don't mind what it's called.
No, I was just puzzled by it, really. It was odd. It was in tab 1 too of the core bundle.
If I could just, I did threaten to go to a CJU decision. If I could bring together the submission by simply taking you very briefly to the EMAG and Howard decision in the bundle of authorities. And this is behind tab 8. Facts can be found at paragraphs 14 through to 16 on page 3255 of the report. In essence, in 1996 and 7, EMAG had obtained certain metals from another company, KGMH. Both of them were Austrian companies. K, who was EMAG's supplier, had acquired those goods from certain suppliers in Italy or Netherlands. It was not disputed that EMAG did not know who suppliers at the higher level of the transaction chain were, but after each transaction, K instructed its suppliers to hand those over to a forwarding agent who delivered the goods by lorry either directly to EMAG or on EMAG's instruction directly to EMAG's customers. And K invoiced EMAG the agreed purchase price of the goods and added Austrian VAT at the rate of 20%. So there were effectively two successive supplies by Austrian registered companies, but they related to the supply of goods cross-border from Italy or the Netherlands. One of the issues was where you have two successive supplies like that, which one is the cross-border movement of goods? And the overall scheme of the provisions governing cross-border movement of goods was addressed first. The court will see that at paragraphs 29 through to 31 of the decision. That's at page 3260 of the report. Please could the court read 29 through to 31. So one has a yin and yang system whereby an exempt supply in one member state is necessarily met with a taxable acquisition in another, where it's a business-to-business supply. The court then looked by the second and fourth questions at paragraph 32 at what happens where you have two successive supplies on the same goods, but only one dispatch. And ultimately where the court came out on this, at paragraphs 37 through to 39, is as follows. That if the proper analysis is that you have first an intra-community transaction and then a purely domestic transaction, then the first supplier is the one making the exempt supply of goods, and the second supplier is necessarily purely domestic transaction once the goods have arrived. If, however, the proper analysis is that the first supply is a purely domestic supply in the first member state, then the second supply would be the one that is the supply to cross-border to the member state. And that depends really on an analysis of which of the two supplies is the one that is characterised by the intra-community movement. Now, the complicating factor here, of course, was that you had one transport and two related supplies, but it was left for the National Court to work out which of those two successive supplies had to be treated as the EU transaction, so the cross-border transaction. What the court said you can't have is both of those supplies being treated as EU transactions, because that would be a nonsense.
Yeah.
You have to have one or the other. Yeah. Then at 46, the court turned to a different question, which was question 1 of the reference, which was the determination of the place where the supply is deemed to take place under the 6th Directive. And that made clear that it drew no distinction between intra-community supplies and internal supplies as such. Article 8.1 dealt with, and this is now Article 32 and 33 of the Principal VAT Directive, Article 8.1 dealt with a distinction based only on whether or not supplies of goods were dispatched or transported, as opposed to those goods which were not dispatched or transported. As we saw, Article 31 deals with a purely internal situation, no dispatch, and it's where the goods are effectively delivered. Where you have goods which are dispatched or transported, the place to supply rule is different. and it followed from the answer to the second and fourth questions that in a situation issue in the main proceedings, it was the single intra-community movement of goods that could be ascribed to only one of two successive supplies. Turning over the page at 49, as the other supply did not involve a dispatch or transfer, the place of that supply was deemed to be the place where the goods are when that supply takes place. It followed from that you had two particular scenarios that would arise under paragraph 50, and they depended on whether or not the first transaction was the intra-EU one and the second one was domestic, or the first transaction was domestic and the second one was intra-EU. That may sound convoluted, but what this boils down to is once you've identified which one is the one that moves across a border, one set of place of supply rules applies, and then when the goods have either arrived or been deemed not to have been sent in the first place, you have a purely internal supply. How that plugs in here is if it's the case that there is a supply by my client, but at the same time there is a cross-border movement, it is important to distinguish what the movement is that takes the goods cross-border. And if that's not my supply, because somebody else is making it, then the place of supply rules will determine that whoever is making that supply is making an exempt supply of goods cross-border, and whoever receives that supply is making a taxable acquisition of those goods. Putting that into the facts here, if it's right that we had the goods, we then didn't have the goods, somebody else moved the goods cross-border, then the proper analysis from EMAG and Handel would be that the supply that we made is not the supply that goes cross-border, and therefore has to be treated as a purely internal supply, which would necessarily be in France. If
just a moment. Yes. Okay.
If it would only be if we were responsible for the dispatch of the goods.
Sorry, only
if we're responsible for the dispatch of the goods, then there is a taxable transaction that takes place. But again, that would be us being the supplier of the goods cross-border, which would be an exempt supply.
So only if A was, it would only be if Award was responsible for the dispatch of the goods, to be in England?
Yes. That there would be a cross-border supply. And that cross-border supply would necessarily be an exempt supply in France.
Just hold on. So that would be exempt in France. Yes.
And there would be a corresponding taxable acquisition by whoever the recipient was in the UK. Now, in fact, we don't get there precisely because of the concession that's been made by HMRC.
So you say the concession leads you to the first of your alternatives?
Yeah, which is there was a...
I mean, the third alternative is that you simply transported the goods from England to France and then yourself sold them in England.
Well, that third alternative would require there to have been no interceding fraud by other people. And no inward diversion fraud. So that hypothesis would work. I mean, in a sense, if I can be brutally honest here, if HMRC had simply said, we don't like the fact that you've got this cash, we think there's a supply, it's up to you to prove it, as I said earlier, we wouldn't be here. It's because they've done some of the homework and they've established that there's an inward diversion fraud, and they've established that these French excise goods have been smuggled into the UK on their case, that we are where we are, because they've done half of the work, but they haven't done all of the work to show what they no doubt want to show, which is that we're somehow involved in a fraud, which of course we deny. So the position we're left in is HMRC say, well, yes, this is all part and parcel of an inward diversion fraud, we don't say you were party to it, and we don't say you were involved in it. We say that the people who were involved in it were either your suppliers or your customers. And we accept that it was those people, not you, that diverted these goods across the border. Now, as a matter of VAT analysis, what that shows, given that the goods came from us and were then held by somebody who, in inverted commas, smuggled the goods across the border, because...
But you could have smuggled the goods across the border, couldn't you?
No, because it wasn't
Why not?
alleged that we were part
No,
of it.
no, never mind about allegations. I mean, I mean, there's nothing in the VAT setup which would prevent you, as it were, from smuggling. Of course, that's entirely contrary to VAT. But I'm just putting to you, not you, X owns goods in France, wants to bring them in to the UK and then sell them here and get the arbitrage advantage to which you refer.
Yes.
Well, you could illegally do that, couldn't you?
Well, the smugglers here did illegally do that.
Yeah, that's right. But you could be the smuggler. I mean, there's nothing impossible about a ward being the smuggler.
Well, my lord, I would say that is impossible.
Why is it impossible?
Well, it's not what we did.
Well, we don't know. But I mean, I'm sorry, you misunderstand me.
Well, my lord's saying you could have committed criminal offences.
Yes, of course.
Could.
Yes, yes. Well, that's all I'm trying to understand. So that is a third alternative.
Well, except, of course, that the whole point of chasing down the commissioners with the FBPs was to make sure that we didn't face that possibility as a possibility. Because if we had faced that possibility, we would have sought to deploy the 99 lever arch files of material.
I don't know why this wasn't just then the whole case.
But because it wasn't alleged against us.
Right. That's the point. So you could have said, HMRC, you're bound to lose.
Well, we did.
Well, you didn't really. You adduced a whole story which was rejected,
well,
which is wholly contrary to.
Mr. Jones had, as we've seen, the unsuccessful attempt to say that as a matter of law, it necessarily followed from what was being said in the statement of the case, that there could be no taxable supply in the UK.
You could have just got NAP on that.
But at that stage, of course, HMRC were hedging their bets on wishing to allege fraud.
Well, after they'd made their position
After
clear.
they'd made their position, I won't say clear, because with respect it didn't become very clear. But once they'd said that they weren't alleging fraud.
Yes, you could have just said, well, there we go. After the F&BPs were provided, well, you've conceded the game.
But that is what was said in the Upper Tribunal.
All right. Okay.
I mean,
well, in the Upper Tribunal, yeah.
I mean, to the extent, as I've said, it was touched on lightly in the transcript reference I've given you.
All right.
I accept it wasn't front and centre of the way that submission was made, because the client took the view that his explanation of events was credible and ought to be believed, and he lost on that. But it doesn't alter the fact that the argument was then run properly before the Upper Tribunal, i.e. Fully deployed. The Upper Tribunal decided it wasn't going to address the argument because it felt it didn't need to, and that was an error of law. The FTT decision, I reiterate, I appreciate, has in fact been set aside for deficient reasoning. And so it's the Upper Tribunal decision that I am appealing against.
Yes.
In the minute or so, I think I could probably commit to, before outstaying my welcome will and truly, could I just say this on Brady, that in the VAT context, best judgment is usually a question of quantum rather than liability. That in circumstances where, even under the Brady doctrine, where, for example, under Hudson and Humble's principles, what's being put forward is a claim for fraud in order to extend time for an assessment to be made, it's still recognised there that the burden's on the Crown to plead fraud in order to get the benefit of the extension of time. If what is in fact being relied upon here is an allegation of fraud to show that we were somehow involved in the diversion of the goods from France to the UK, and therefore the supply necessarily has to be attributed to us, then that would be a positive assertion of fraud, and that would have to be something we say that was properly pleaded. And as I say, I put down the marker earlier on whether what we would say shouldn't matter have to go further. I think the only other point I wish to develop is the simple fact that ordinarily VAT is a transaction by transaction tax. So one looks at what goes in and what comes out. What you generally don't do is look at more than one transaction at a given time. So you don't look at what happened earlier in the transaction chain or subsequent to the transaction chain. That sanction, that approach, necessarily goes out the window if one's alleging fraud or knowledge of fraud or indeed abuse of process, Halifax abuse, because there one has to consider multiple transactions, perhaps involving multiple parties, and to some extent under Halifax, a recharacterisation of the transactions that have taken place. That isn't this case. And so one does have to focus not on what may have happened between unidentified people in France delivering goods to the UK to unidentified people. One has to focus on what were the transactions that the assessment says my client undertook in the UK. And here, given that we had necessarily dispensed with possession of the goods, we respectfully suggest it simply cannot be established as a matter of VAT analysis that we made a supply of those goods in the UK, because we no longer have. Yeah. My lords, my lady, in terms of relief, the two options are you accept my submissions and the inevitable consequence that follows from them, that the Commissioner's case is flawed and was flawed, and the Upper Tribunal should have recognised that. Or, if you feel that the way that the case has been pleaded and proved has been, in any event, ambiguous, then the other option would be to remit it for a fresh hearing before the Tribunal and start from scratch. That would require a new pleaded case and with respect to perhaps a new composition of the Tribunal, so that they weren't otherwise feeling hidebound by findings that were no longer appropriate.
Thank you.
Would your Lordship, your Lordship, give me a moment?
By all means, do ask.
Well, can I just ask what might seem a really stupid question, Mr. Beale? Never mind how the goods got to the UK. Why is it not legitimate to draw an inference from the fact that all this cash is deposited in various branches of Barclays Bank in your client's account, that there were sales in the UK by your client, never mind how the goods got there and all the rest of it?
My lady, because it was a necessary function of the Commissioner's case that these excise goods were originated in France, and the reason for them being in the UK was to derive the arbitrage on the duty rates. And so there's no commercial rationale for the sale of goods in the UK. It would be a straightforward suppression of suppression of declared earnings by a taxpayer, and that isn't this case. So this isn't a case where, for example, commissioners conduct test purchases in a wholesale store or retail store and then see that those particular goods haven't been declared for tax purposes. This is a case where they say, no, these goods have come across border from France and they've been slaughtered on the illegitimate black market in the UK, undercutting properly available domestic consumption goods, and that is the modus operandi of the fraud in question. So, as I said earlier to, I think, a question from the bench, if the commissioners simply said, we've got this money, we don't know where it comes from, explain yourself, that would be classic Brady territory, and we wouldn't, with respect, be here. Because there wouldn't be the added complication of the cross-border movement. It's necessarily, and in a sense unashamedly, my case, that what makes this case different from the classic case is the cross-border movement. And because of the place of supply rules and the different VAT treatment that's given to an exempt supply and a separate taxable acquisition of goods. And there's a different party that has to pay it as well. So not only do you have an exempt supply in one country, a taxable acquisition in the UK, the person who is liable to pay is the recipient and not the supplier. And so it wouldn't make sense to say you are liable because you are the recipient of goods as a supplier, because that isn't what makes you liable. So, the short point is we deliberately sought to confine the commissioners to understand what their case was. They gave us what their case was, and they made the concessions they made, and we reacted and dealt with our evidence on that basis. If they had simply said you were involved in fraud and you knew or should have known of the fraud, we would have been in classic carousel territory with 99 lever arch files of documents showing the various different transactions that had taken place. There would have been a very different picture presented to the First Tier Tribunal. But as you've seen, the counsel who presented the case below had assumed that the Commissioner's case was the Commissioner's case. Unless I can assist any further, I think it falls to me to put my mask back on.
Anything else? Okay, thank you very much, Mr. Beale. Yes, Mr. McGowan.
My lords, my lady, thank you. I'm going to pick up essentially where my learned friend left off. My lords, my lady, this is an ambitious appeal, and is more ambitious when one considers that a new counsel team, a new solicitor team, is running essentially an entirely new argument. They put before this court a number of authorities and pieces of legislation that were not put before either the first tier or the upper tier. Half of the legislation now cited in all of the EU cases relates to intra-community supplies or intra-community acquisitions in support of a case that is what the fact of this case gives rise to. Now, starting with my Lord Justice Richard's opening remarks to my learned friend, in fact the way this case was argued in the first tier and the upper tribunal was that the relevant provision of the PVD was Article 2.1a, not 2.1b. And to my Lord Justice Richard's point, the question was either, was a taxable supply, for purposes of Article 2.1a, made in bond in France, which was the appellant's case below, or was a taxable supply for the purpose of Article 2.1a made in the UK? And that was the Commissioner's case. There was no argument at all about Article 2.1b or any of the provisions involving dispatch or movement in that section of the PVD that encompasses Articles 31 to 33, which my learned friend has taken you to. And of course, you've seen the paragraphs 20 to 29 of their skeleton for this court, which sets out their case based on a legal argument that the facts of this case involve an intra-community supply and a corresponding intra-community acquisition. And they run their case on the basis that the tax treatment follows that analysis. As I say, that is a brand new case. And can I make this good? Noting that they rely specifically on Articles 32 and 33 in paragraphs 23 and 24 of their skeleton. Again, articles presupposing an intra-community supply. But that point was tried to be pursued in the Upper Tribunal by way of an amended skeleton argument that was filed shortly before the Upper Tribunal hearing. And the Upper Tribunal were troubled by this. And the very first thing that happened when Mr. Howard got to his feet in the Upper Tribunal was that the court asked if he was taking a new point for which, a new ground for which permission had not been granted. And if I can ask the court please to turn up the core bundle, the Upper Tribunal transcript, page 80. And perhaps you can see Judge Raghavan at line 5 on page 81, immediately raising this point with Mr. Howard. And if you could just read down to about line 20. And then turning over the page to page 82 of the bundle, page 2 of the transcript, Judge Ragavan at line 25. I think my understanding of your supplemental skeleton, there are some elements which, the bit that we are interested in addressing at this point, does it raise a new ground and without permission?
Sorry, where are you?
I'm so sorry.
Oh, yes, I see at the bottom.
Yes, it's 25 to 29.
Yes.
Does it raise a new ground and without permission? And that is the Article 32, Article 33 point. Now, I don't want to labour this, but the discussion between Judge Scott, Judge Ragavan and Mr. Howard continued for a number of pages up to 87. Going to line 33 on page 87 after my reply as to why this was a new case and why I would be prejudiced by it, there's some further argument, and at page 91, my lords, my lady, at line 34 of 91, you'll see that the tribunal rose to consider the argument to whether or not this was a new ground for which permission hadn't been granted. Now, the outturn of that on the hoof preliminary hearing is reflected in paragraph 16 in the Upper Tribunal's decision, and that's in the core bundle at page 60. The Upper Tribunal noted that the ward also sought the supplementary skeleton filed without permission on the 26th of February to raise a new ground of appeal for which we refused permission on the first morning of the hearing. Having considered the parties' respective submissions, the grounds concern the application of the general rule in Article 32 of the PVD, that the place of supply is deemed to be the place where the goods were located at the time when dispatch or transport to the customer began, and the non-applicability of the derogation in Article 33, which applies to transport by or on behalf of the supplier. The ward argued that because HMRC had disavowed any allegation that the goods were moved by way of inward diversion to the UK by or on behalf of the award, and that's an important point which we'll come back to for obvious reasons, the UT fully understanding the scope of what was said in the FPBs. Applying the general rule, Article 32, the place of supply was therefore France. For the reasons explained at the hearing, we refused permission for the new ground to be raised. In brief, we agreed with HMRC the ground raised a point which would have altered the approach taken to the evidence at the hearing if raised earlier. And so they refused permission to run a case expressly on the basis, for the first time, that these facts gave rise to an intra-community supply and as a corollary an intra-community acquisition. Now, there was no appeal against that preliminary ruling, and no permission has been granted to address that preliminary ruling, and the refusal to allow the appellants to run intra-community supply or intra-community acquisition pursuant to Articles 32, 33, or any other provision in that section of the PVD. Yet it's where my learned friend starts from in this appeal. Now, if it was not permitted by awards to run that argument in the UT, and that ruling wasn't appealed, I cannot for the life of me see how it can be pursued as an argument in this court in support of a contention that the Upper Tribunal erred in law. It wasn't before the Upper Tribunal. So whatever else the correct analysis of the facts may be, it cannot at this stage of the proceedings involve sluicing the facts through Articles 32, 33, or any other provisions that treats them as intra-community supply with as a corollary an intra-community acquisition. What we're left with is Lord Justice Richard's opening point, the positive case that was run in the First Tier and the Upper Tribunal by award, that there was a supply made internally in France in bond that meant the suppliers couldn't be subject to UK VAT. And alternatively, HMRC's case, that there was a UK supply for the purposes of Article 21A of the PVD, entitling HMRC to raise the assessments they raised. So that's the proper framework in which we should consider the facts and the legal analysis that applies to the facts. And as I say, it's the way the case was brought and pursued by the appellants in the first tier, albeit slightly refined in the upper tribunal in light of how the evidence went for them. I'll come back to that. Now, with that introduction, if I may, I want to take my submissions in 3 stages. First of all, I want to put ground 1, which is a very narrow ground about a claimed mischaracterisation of the Upper Tribunal of HMRC's pleaded case in paragraph 50, single isolated paragraph in the judgment, into its proper context, both as a matter of substance and as a matter of procedure in terms of how the appeals have come to this court. Second, I want to address ground 1 and explain why the UT made no error as alleged. And third, I want to say a few things about disposal if you were against me on the substance. So as to the context, the appellant was owned and controlled by Mr. Judd. For all intents and purposes, he was the business. The appellant was in the business of selling alcohol, and it did so availing of the duty suspension regime, whereby alcohol can be bought and sold tax-free in duty suspense. It held accounts in bonded warehouses on the near continent, and it purported to sell alcohol in bond to French traders who held accounts, at least nominally, in those same warehouses. Now, the brands of alcohol in question, as was effectively common ground in the first tier, were brands that were popular in the UK. So Tennant Super, Kestrel Super, brands that are largely manufactured in the UK and consumed on UK markets. And that may explain why my reference in various drafting points to move back was not a tick or poor drafting, but reflected the fact that it was always anticipated that those goods would return and be supplied to a UK market. French not known for their fondness for Tennant Super. The case before the FTT arose in circumstances where the appellant had, as the court has seen, banked £32 million in 1,300 transactions in less than 2 years. As the court has appreciated, these receipts from the sale of ADL's goods, and that money was paid and banked in sterling in branches all over the country. Now, in circumstances where the appellant had claimed that its business was confined exclusively to selling alcohol in bond in France, as my lady put it to Mr. Beale, the position in relation to making deposits all over the UK gives an air of unreality to the claim that was pursued in the first tier. These could ever be credibly suggested to be the receipts of in-bond sales in France. That was the case that was run, the case that was comprehensively rejected. Now, just on this point, there's another new line in my learned friend's submissions that I object to, with respect. If we could turn to the appellant's skeleton, paragraph 10, in the core bundle, page 20. You'll note the point that he's taken and that my learned friend came back to an opening this morning.
Sorry, I've put in the updated skeleton, which has the references. So could you give me the paragraph number?
Yes, it's paragraph 10.
Oh, sorry, it is paragraph. Forgive me.
I didn't realise there was an updated skeleton.
Well, it's simply got, as I understand it, simply got the references to the core bundle and so on.
I don't think it'll matter.
Okay.
I think I can give you paragraph numbers and we can do that.
No, I don't think so. No.
So in this paragraph 10, he said, on the 23rd of December 2015, my learned friend took you to this, HMRC reduced the assessments, leaving only those transactions where commissioners considered that the origin of the payments had not been sufficiently evidenced. In summary, HMRC accepted where a direct electronic payment had been made into ADL's bank account in respect to a particular consignment of alcoholic products. No UK output VAT was due on the transaction because it took place at a bonded warehouse located in France. Now, we don't accept that, and my learned friend took you to the letter in the core bundle, page 32. the supplemental bundle, page 32. But authority for that proposition is the First Tier's judgment, paragraph 46. So if we could turn up the First Tier's judgment, page 224 in the core, paragraph 46 is on page 242. This is the section of the judgment. This is the section of the judgment where the First Tier is dealing with the history of MLR visits made by officers to Mr. Judd over a period of a number of years. And it says here, although the report of money laundering compliance visit on the 30th of November stated that the award drinks should be revisited in 3 months, the next such visit took place in January 2012. The report for that visit records that Mr. Judd informed the officers that there were at that time only 2 customers paying in cash. We now know that to be wholly false. And that by the end of February 2012, all payments would cease to be by bank statement or cheque, and that high-value cash payments would cease. And again, that did not come to pass. The report concluded, given the explanations provided by Mr. Judd, its customer due diligence, reporting, record-keeping, internal report, control, risk assessment and monitoring and management of compliance was satisfactory. And you can read down to the bottom, my lords, my lady. Now, there's nothing in that supports what is said in the appellant's skeleton at paragraph 10. This was not a finding by the First Tier. It was simply recording that at a further MLR visit, monitoring and management of MLR compliance was at that stage satisfactory. Something, as you'll see from the judgment, Miss Kenning, who gave evidence on the MLR history, strongly disagreed with. Now, this was at a stage in 2012 where we're still over 2 years off the issue of the assessments that are challenged in this appeal. And so HMRC are still investigating the matter and assessing the commerciality of the supplies being made, credibility of the story proffered. And they're not saying that they were content that all sales that gave rise to electronic payments were somehow fine. There's nothing in paragraph 46 of the Tribunal's judgment that supports that. And therefore we don't accept what is presented in paragraph 10 of this skeleton argument at all. Paragraph 11 of the skeleton, Malone and friends go on to say the assessments as amended were calculated on the basis that between January 2011 and December 2012, ADL received into its account cash deposits totaling 32.6 million. There was no attempt made by HMRC, or therefore by the FTT, to explain why it was fully accepted that genuine wholesale transactions had taken place between ADL and its customers when payments were received electronically. Again, it wasn't fully accepted. It wasn't accepted at all. And this is the letter at page 32 of the supplemental bundle, where the Revenue effectively reserved its positions to the legitimacy of those transactions. I won't take you back to it because Malone and friend has showed you that. But that letter is not a basis for any contention that it was fully accepted by the Revenue, that the electronic transactions giving rise to electronic payments were genuine wholesale transactions. There is no basis for that contention at all. Now, importantly, coming back to a best judgment attack on an assessment, neither the FTT nor the Upper Tribunal, in neither of those tribunals, did the appellant or its counsel contend that the assessments could be impugned because HMRC decided only to investigate and then raise assessments in relation to those transactions that gave rise to payments in cash or cheque. That was the scope of the investigation and the scope of the assessments that were raised, and it wasn't challenged as being not to best judgment. That second, when Malone and friends say that there was no attempt made by HMRC or therefore the FTT, this is paragraph 11 again, to explain why it was fully accepted, that these were genuine wholesale transactions, a characterisation we don't accept, First of all, my lords and my lady, nothing in paragraph 46 of the FTT, again, indicates, as I explained, that HMRC did accept that these were genuine wholesale transactions at all. And second, in seeking to impugn the rationality of the scope of HMRC's investigations, and thus the assessments raised, that very much amounts to what would be a stage 1 rationality attack of HMRC's best judgment. That is not a matter that has ever been pursued in these appeals. That was common ground in the FTT. Such challenge being based on quasi-Wednesbury grounds, of course. And it was well understood that that stage 1 best judgment attack was not being made by the Upper Tribunal as well. And if we could turn to the Upper Tribunal transcript, again in the core, it's page 91. And lines 19 to 22. We see that Judge Raghavan said that the question determined by the FTT was whether you had satisfied the burden of proof to discharge a best judgment assessment where the appellant's contention, rather unusually for a best judgment case, was not the best judgment had not been exercised because it was an irrational assessment. That was not argued. So that was common ground. We're not in stage 1, we're at the territory of asking whether the assessment was right, in inverted commas, i.e. the quantum stage. So again, my lords and my lady, I strongly object to paragraph 11 of my learned friend's skeleton insofar as it appears to be resurrecting, or indeed running for the first time, some form of best judgment attack on the scope of the investigation and assessments.
Well, if it's any consolation to you, Mr. McGurk, I had written against this, no PTA.
Thank you, my lord. I'll move on. Now, returning to ADL's business model, the question, of course, then was from what sales or supplies was that 32 million in sterling the consideration? And we're back to the dichotomy that my lord puts in my learned friend, and it's a dichotomy that has to be framed within Article 2.1a of the PVD. Now, the appellant's answer to that question has always been utterly implausible. Its case was that it sold goods to genuine French cash and carries in bond in France. It claimed those cash and carries acquired property in the goods and sold them on to UK day trippers on the so-called booze cruise market, UK travellers who came to the near continent to avail of lower rates of duty, as we've discussed. Now, it claimed that the reason why those businesses paid the appellant in sterling was because those cash and carries were content to charge UK day trippers, not as you might expect in euros, but rather in pounds sterling. Now, HMRC's evidence, which was accepted in the first tier, was that this occurred at a point after which the bottom of the booze cruise market had fallen out, and at a time when some of the very famous Calais cash and carries like EastEnders and Tesco's own branch had long since closed. Now, HMRC also led evidence that those so-called cash and carries were located at sites in Calais that were effectively run-down industrial estates at locations nowhere close to the ferry terminal or the Channel port, and therefore completely inconvenient to UK day trippers coming from the UK through those means. Now, HMRC led evidence that these premises were completely unsuitable for sales to UK day trippers. One outlet was a service business centre, which was the registered address for 3 of the alleged customers, with no storage space at all for goods. Brass plate outfits. None was set up to operate as a cash and carry, none had a trading history, none had capital or the means to start making immediate payments in the tens of thousands, the average deposit in the UK bank accounts in this case being about 22,000. And almost none of them had a French bank account. Indeed, during cross-examination and faced with the implausibility of what had been claimed about these cash and carries, given the weight of evidence to the contrary, Mr. Judge changed his story, and this is recorded by the FTT, that whereas his case had been founded on the claim that they operated as retail cash and carries, selling direct to UK day trippers, he pivoted to say, no, we sell wholesale to wholesale. And of course, that was rejected. Indeed, it was rejected by the FTT in the context of impugning the credibility of Mr. Judd. This was one of the examples of a plain volte-face. Yet Malone and Friends skeleton cites as a fact that ADL was in the business of supplying wholesale to wholesale, something which was expressly rejected. That's paragraph 8 of Malone and Friends skeleton. So that contention is just not true. So it was only in closing, and after Mr. Judd's radical change of position, that it was contended in Mr. Howard's closing submissions that this ADL was an entity that made wholesale supplies. Now, in short, none of these businesses was legitimate and none was engaged in the business of selling alcohol to UK day trippers. Mr. Judd was unable to name any of the people said to be behind those businesses, notwithstanding that he claimed to have done detailed due diligence on them before commencing a trade with them. And that evidence all fell apart on cross-examination. Now, it was staggering, my lords, my lady, in a case like this, where the credibility of the French cash and carries was central to the appellant being able to discharge the burden on it, and they'd had the pleading, an earlier version of the pleading since 2016. So to some of the questions from the bench, there was ample time to put in a positive case, call witnesses from these cash and carries, explain how the trade took place, how the relationship started, provide some support to the positive case that was sought to be run, that taxable supplies were made in bond in France. But none of them were called, and we know why from the French revenues reports, namely that having tried to contact them themselves on occasion to enforce outstanding VAT liabilities and penalties and surcharges, they simply were uncontactable. They had disappeared. So we say that these French cash and carries were not legitimate, and they were rightly described as HMRC as buffers or conduits, however you want to describe it, whose only purpose was to make it appear as though a sale or a taxable supply had in fact taken place in bond, by which the appellant had divested itself of ownership, possession and control of the goods, and pursuant to which it received consideration, neither of which was the case. Now, undeterred, the appellant's case then was, rather than be paid by way of bank transfer from these so-called cash and carries, the appellant would, at its risk, and we were told the practice was uninsured, which was lacking in all commercial credibility, it would send what came to be known as the cash couriers back and forth through the Channel Tunnel, and those cash couriers would, the appellant contended, collect the cash, and they would drive it back to the UK. Now, the appellant claimed, at least before the FTT, that the French customer would pick up the tab for this, without apparently any discount in the cost price for the alcohol allegedly sold to it. And this proposition was unevidenced and completely commercially implausible as well. The first point is that the alleged cash couriers were English nationals living in the UK. Some of them are named in the judgments below. And the appellant didn't call them, didn't seek to call them, as Mr. Judd confirmed in cross-examination. It was HMRC's case that the named individuals were not cash couriers and didn't undertake this couriering, whether as alleged or indeed at all. Now, notwithstanding that the appellant well knew, as Mr. Judd accepted in evidence, that French law required sums of money in excess of €10,000 being declared in a customs declaration form on exit from France, notwithstanding all the evidence that in the course of the MLR visits, Mr. Judd confirmed to HMRC's officers that he understood the obligation to make such declarations as they left, there was not a single customs declaration filed in the evidence exhibited in Mr. Judd's statement. And there were no cash couriers because the so-called French cash and carry companies were missing traders, they weren't engaged in legitimate sale, they weren't taking in money from UK day trippers, and therefore there was no money to go back on the back of motorbikes. My lords, my lady, the story in a sense became even more implausible when the alleged couriers got out at Dover on the return leg. Now, you might expect, given the risks of carrying that amount of cash on the back of a motorcycle, that you would deposit money in the first bank that you could find. Indeed, you might imagine, first of all, that you would hire Loomis or Securicore to do the couriering for you. But leaving that to one side, you might think that they would immediately deposit the cash at the first Barclays branch in Dover. But we had a, quote, cock and bull story about why the branch in Dover wouldn't accept these sums, whereas every other Barclays branch in the country seemed to be perfectly happy to take these deposits. Now, if these sums were the product of sales in France, there was absolutely no logic or commerciality in banking those sums at branches as far north as Lee in Lancashire. The other point to note on this, to my lady's question to my learned friend, there was evidence that more than one deposit was made to particular branches in the same day, or that bikes were coming on the Wednesday and then the Thursday, allegedly from the same outlet in France, and making multiple deposits. But if that was true, why would you not send one bike up on day 2 with the 3 amounts of cash that were deposited in 3 separate branches in question? Again, it made no commercial sense at all. HMRC's case was that these weren't the product of motorbikes bringing cash from any genuine sales in France. Rather, these were deposits which were the product of sales of what remained the appellant's goods in the UK, and it was consideration for the sale of those goods, and the FTT and the UT agreed. There was then the evidence as to the actual source of some of the payments that were made to the UK, the appellant's UK bank accounts. Now, much of the money was, of course, received in cash sterling and deposited in the overnight boxes with payment slips. But some of the payments were made by by cheque, and those cheque payments, I think, exceeded 4 million. Now, HMRC's Officer Martin produced a reconciliation of the alleged transactions with the payment information. It couldn't be done with the Sage accounting information that was provided by the appellant on its own, and information was provided by Barclays, so HMRC did the work in trying to link deposits with transactions. And the appellant contended that some of the monies deposited by cheque by 2 UK companies were companies who were making payments on behalf of French cash and carry customers. Yet those 2 UK companies, AF Wholesale and Jackson & Co., under cross-examination, appeared to have, Mr. Judd under cross-examination, appeared to have no explanation as to their involvement, couldn't describe their business, and not least because Jackson & Co. appeared to be an estate agency, there was no obvious explanation for how they came to be involved in handling money derived from alleged sales of alcohol in bond in France on behalf of these cash and carries. On further questioning, Mr. Judd could provide no evidence of whose companies they were, what their role was in the context of these purported supplies. Now, Officer Martin's reconciliation showed that there were 6 other UK companies involved making payments by way of cheque. Again, on questioning, Mr. Judd could provide no evidence who those companies were, what their role was in the context of these purported supplies of alcohol, and how they came to be, as might have been suggested, making payments on behalf of those companies. Moreover, Mr. Martin's reconciliation, which wasn't materially challenged in cross-examination, demonstrated that some of those payments that the appellant claimed had come in cash from their French customers had in fact been made by way of cheque from one of these 8 UK companies. Now, there was further evidence heard about the paying in slips used by those depositing vast sums at branches, the appellant's bank up and down the country. The slips never identified the customer or the particular transaction. Again, this was a problem that you couldn't reconcile this information from the appellant's documents alone. So Mr. Judd was asked how these slips could be married up with an alleged payment by an alleged French cash and carry customer. Mr. Judd's preposterous response was that although he accepted the slips provided no traceability from the numbers on their heading, the individual bank branches could use their CCTV to identify the cash courier who paid the monies in under those slips. Again, it was just utter nonsense. Now, there was just no evidence that any of the sums banked in the UK were being paid by the alleged French cash and carry customers at all. It was consistent with our case that they didn't exist and had no visible means of support. Finally, as to how the goods were returned to the UK, there was incontrovertible evidence from Officer Llewellyn that the ARC documents used, being the administrative documents issued under the EMCS system to enable movements to take place in duty suspension, had been found to have been used more than once in respect of some of the appellant's goods transferred into the UK by way of Scorpion. Now, given the very nature of inward diversion fraud, very often HMRC are faced with cases where assessments are raised and they can't point to any particular link between the taxpayer's goods and the process by which they are returned to the UK. We had that evidence, unusually in this case here, and that was exhibited to Officer Llewellyn's case, and the FTT dealt with that at paragraph 73, 75, core bundle, page 250. I won't turn it up. Just on this issue, and before getting into the meat of whether any concession was made or not, I suspect you know my case on that. One point to note, and it wasn't dealt with by my learned friend in his submissions, but if you could turn to page paragraph 78.6 in the UT's substantive judgment. It's in the core bundle at page 75. Our case, of course, was that we didn't take the burden of pleading or proving fraud. We made no positive case of fraud against Award or any of its agents because we didn't need to. But we had, to my Lord Justice Henderson's point to my learned friend, put Award on more than sufficient notice that we were going to impugn the credibility of the business model that said justified the claim that these were genuine receipts from genuine in-bond French transactions. Now, it's not before this court, but the full set of transcripts and the complete run of witness statements were before the Upper Tribunal. And the evidence that they saw in the transcript allowed them to conclude as they did at 78.6, where they say some of the documents showed Award was dictating what happened in practice to the goods even after their purported sale. So in a sense, the case got worse for ADL upon analysis of the documents that we had available to us. So to my learned friend's repeated contention that we were not involved in this, we had handed over the goods, we don't know who they are, but it wasn't us, which is a factual claim, is in fact undermined by the evidence that came out on cross-examination by reference to their own documents in the FTT. And that's what's picked up here at paragraph 78, 6. Now just turning to the, and just finishing on that, notwithstanding how that evidence came out, we didn't ask the First Tier to make any finding that therefore there was, after all, fraud perpetrated by Awards or their agents, even though on the basis of this evidence that submission could be made. We didn't need to. We hadn't positively pleaded it. It was just more evidence in the balance in the context of a Brady case where the burden falls to my learned friend's clients to knock down the assessment as being incorrect. It just put more weight in the other side of the scales as to how implausible all of this was, and in fact further linked Awards with the untoward supply chains and how the goods were getting back to the UK. But we didn't do any more with it other than to say further evidence that this whole narrative about the legitimacy of this business model is just not credible. So turning then back to the FTT's findings, First, as to credibility, my lord and my lady will have seen paragraphs 15 to 18 as to Mr. Judd's complete lack of credibility. He was found not to be truthful. And where there was a conflict between a document and what Mr. Judd was saying, and between what a revenue witness was saying and what Mr. Judd was saying, the court would always prefer the document or the contention of the revenue's witnesses. And my learned friend has taken you to the core of the conclusions and discussion at paragraph 79 to 82. The court's read that, so I won't go back to it. But we say from those paragraphs it was clear that the FTT considered the deposits reflected the fact the appellant was not engaged in genuine trade in France, and in particular did not make genuine sales in bond, or therefore taxable supplies for the purposes of Article 2.1a of the PVD, to its alleged French cash and carry customers at all. And we say the last sentence in paragraph 82 makes it clear, if implicitly, the FTT was not satisfied that the appellant ever transferred possession or control to anyone else in France, such that the sums in sterling deposited in the UK represented the proceeds of UK taxable sales, following, in all likelihood, sales at slaughter sites up and down the country. So we say it's wrong for Malone and Friends in their skeleton, paragraph 12, to characterise the FTT as having effectively found that HMRC was entitled to raise these assessments merely because deposits of money were made in the UK. To my Lord Justice Henderson's point earlier, you can credit the revenue with a bit more wit. That's not how the VAT system works. Nobody was raising an assessment on the basis that money had been deposited in a particular country. It is clear from not just the discussion at the end, which was admittedly brief, but from all the findings and observations the FTT made on the way, it was a much more detailed run-up, it has to be said, that the FTT was simply not satisfied that there was any divestment of ownership, possession or control by the appellant, such as to amount to a taxable supply of goods in bond in France for the purposes of Article 2.1a of the PVD.
And that's how the Upper Tribunal, I mean, that's what the Upper Tribunal understood the FTT to have found. See paragraph 80 of the Upper Tribunal's decision.
Yes, ma'am, and to your point about paragraph 92, they adopted it wholesale, but to the extent there was any suggestion that there was a gap in the reasoning, they wished to make it absolutely clear that the FTT was to be understood as saying, concluding that there was no taxable supply, which at the point at which it came before the Upper Tribunal entailed a finding that there was no divestment of ownership, possession and control. Although, as I'll come back to in a moment, that only emerged in Malone Friend's closing after I'd sat down in the FTT. So the case considerably narrowed from one at the outset of the FTT hearing, whereby there was a positive assertion that there was a taxable supply made in bond in France, to a much more narrow submission made in closing by Mr. Howard. The real issue was a failure of HMRC to show and to put a case to show that there was a divestment for the purposes of Article 14 PVD, such that we could not contend that ADL maintained ownership, possession and control of those goods to allow us to raise an assessment on the taxable supplies we say had been made in the UK. I'll come back to how that developed in a moment. Now, the notices of appeal that got these proceedings underway, Malone Friend's taken you to them. They're at pages 2 and 16 of the supplemental bundle. He has, in fairness, taken you to Mr. Jones QC's very economical pleading behind the first of those notices of appeal. They are, on any view, incredibly thin. It's an approach that smacks of less said, the better, frankly. How these proceedings proceeded all the way up to a couple of weeks before the FTT hearing. Thinness of the pleading. Mr. Judd's statement was incredibly short. Mr. Gluck's statement was 6 paragraphs short, but of course he didn't turn up to be cross-examined. And it was only at that point that Mr. Judd sought to file the documents exhibited to Mr. Gluck's statement in a second statement before the hearing. But it was only at that stage that they tried to put a slightly more positive case in reliance on what is referred to as the IEFW summary report that was produced and appended to Mr. Gluck's statement. That was a document that sought to show, or purported to show, what transactions were made in bond and the fate of those transactions. And of course, it's those documents, included as they are within the cohort of FTDs, French transaction documents, that Mrs. Justice Rose said we have to treat as non-genuine for the purposes of these appeals. But right up to the point of trying to make a more positive case, the appellants had adopted the less said, the better approach in these proceedings. Now, as the Upper Tribunal noted, the appellant pursued this appeal on the positive basis that no supplies, notwithstanding the economy of pleading and witness evidence, Mr. Howard pursued the case on the basis that, positive basis that no supplies could have been made in the UK, as all his sales were made in bond in France. And that was the case that HMRC came to meet in the FTT. Now, these proceedings up to the FTT's hearing had something of a tortured history. There was not one but two applications to debar. There was a number of applications to adjourn final hearings that had already been listed on a range of reasons. And there was, of course, the interlocutory spat about the nature of HMRC's pleading, the extent to which it was pleading fraud or not, and then the application for the further and better particulars. Now, you'll see from the front page of the FTT's judgment that we were permitted to put in the reply submissions that my learned friend has taken to, after the FTT's heard closings from both parties, submissions that the appellant replied to in turn. Now, I want to explain how that came about. I cannot for the life of me remember why we went first and closed first on day 5. It was agreed for whatever reason that we would, and we did. I sat down at lunchtime to foreshadow what happened next. The court must bear in mind that in opening on day 1, Mr. Howard's opening submissions lasted about 4 minutes, and they take up 4 sides of transcript in day 1 transcript. We had no idea what legal case was being pursued on day 1. When I sat down at lunchtime on day 5, I still didn't know what case I was required to meet as a matter of law. And at 2 o'clock, my learned friend came in with a box of files with a number of new authorities, hadn't been trailed in the skeleton, and with a new legal case in tow, including the case that was now being sought to be put on Oliver, the much narrower we lost possession and control, we divested ourselves of property and the goods argument. Now, that case was run, no doubt, because of how badly the oral evidence went for ADL. They could not say in closing, with a straight face, that there were genuine transactions in bond, such as to amount to a taxable supply, as having occurred in France. So they took the more narrow point, in particular by reference to the Oliver decision and Mr. Justice Griffiths then was speech. Now, this was picked up quite astutely, if I may say so, by the Upper Tribunal in its decision, in particular at paragraph 76 to 79. And this comes in the context of the criticism of HMRC that they didn't sufficiently challenge the transactional documents in the FTT. But of course, the case about not losing ownership, possession or control was only put in closing by Mr. Howard when all the evidence had been heard and at the point at which he was making his closing remarks. That's why we got permission to reply in writing a few weeks later. So it couldn't be said in any fairness that I didn't put a case on the basis that sufficient divestment for the purposes of Article 14 had not happened. That wasn't the case that I was there to meet at that stage. I was still there to test Mr. Judd's claim that he was doing legitimate business with the legitimate French cash and carries. Could I invite the tribunal to read paragraphs 76 to 79 of the tribunal's reasoning on this, because it well encapsulates how the case narrowed and why, nonetheless, my challenge to Mr. Judd's evidence included a challenge to the transactional documents, including by reference to whether or not, pursuant to these purported supplies, ADL had divested itself of its ownership and control of these goods. I'm so sorry, my lords, my lady. I think 76 and 79, to be put in proper context, it makes more sense to start at 63, but I do not want to test the court's patience. It's a lot of reading.
The point you're making here, that we're looking at these paragraphs for, is just repeat. What exactly are we looking for here?
So the way the case is narrowed,
yes,
it's said to be a case about whether, pursuant to the transactions reported to bond in France, it could be said that HMRC, ADL had divested itself of ownership and control of the property for purposes of Article 14. It was said against us that we didn't challenge Mr. Judd on this. And that's an unfair contention in circumstances where they had not put their case on that much narrower basis. That was only a case that emerged in closing after Mr. Judd had given his evidence.
Yes.
And the Upper Tribunal recognises how the case went from a slightly broader one about the legitimacy of sales in bonds, such as amount to a taxable supply, which is what we did challenge, to one that became much more narrowly, at least in closing, and then for the purposes of the hearing in front of the Upper Tribunal, case really more about Article 14 and whether divestment had occurred in bond in France, such as to cut the causal connection between those purported transactions and the taxable supplies that we say were made in the UK. And so the UT concludes that no fair criticism can be made against us because of the stage at which the case was changed and narrowed, albeit that they found as an application of the greater includes the lesser, insofar as we were challenging the contention that any taxable supplies had been made in bond in France, that A, there was no such divestment because there was, we said, no supply of goods, purposes of Article 14, and alternatively there was no sale or therefore supply that was supported by consideration. Of course, there has to be consideration for a taxable supply to have been made. So we made our case on both of those grounds, and the UT fairly found, we say, we therefore had sufficiently challenged the French transactional documents, and therefore we had, even on their narrower case now, challenged the contention that they had divested themselves of ownership, possession and control, however you want to put it, for Article 14 purposes. And in any event, as we've seen, we proceed in this court on the basis that we treat those documents as not genuine. So the FTT dismissed the appeal. The appeal brought by ADL was brought on initially 3 grounds. We see that at page 221 of the core bundle. In Judge Brooks's decision refusing permission at this stage. I think it's important just to recall the scope of what permission was sought and thus what permission was granted in these proceedings. Given, and I'll come back to this, given, we say, the expansive approach to what ground 1 permits my learned friend to contend and cover in this appeal in this court. But you see on page 221, paragraph 3, the 3 grounds that were put to Judge Brooks initially. The court would kindly read those appeal grounds. My lord, my lady, paragraphs 4 to 9 will show you why Judge Brooks refused permission.
Do we need to read those?
Not really, safe just to say that...
But, I mean, the grounds, I mean, the unchallenged documentary evidence referred to in ground 1 and ground 3, are they the FTDs? Is that what's being referred to? Yes. Yes.
So, the FTT found as a fact that whatever occurred in Bond in France did not in any way involve the divestment of ownership, possession, or control for the purposes of Article 14. So the goods followed remained the appellant's to dispose of at all material times, including at the time, as HMRC had considered, that they were supplied in the UK. Now, only then was there a supply of goods, and indeed to copper bottom the point, only then was there a supply of goods for consideration, as required by Article 2(1)(a) of PVD. And again, to repeat my earlier point, this wasn't at any stage before today being run as a intra-community supply or intra-community acquisition. And the appellant then renewed its application for PTA to the UT on grounds 1 and 2 only. Permission was granted by Judge Richards. And can I just ask the tribunal, so the court, to look at the Upper Tribunal's decision at page 57 of the core bundle, where at paragraph 3 it summarises the scope of the permission on grounds 1 and 2 that was granted.
This is paragraph...
Paragraph 3, my lord.
3, yes. Yeah.
So you'll see how, as the application for permission to appeal was pursued, it tracked the narrowing of the case that was being put at the very end of the FTT by Mr. Howard in closing. And as he sought then to pursue it on appeal in that much narrower guise, i.e. divestment was now front and centre, rather than the legitimacy of taxable supplies in France. So the UT well understood that the case that ADL was now pursuing, following that narrowing, was that it had divested itself of the property and the goods, such that when they came to be sold in the UK, they were not sales made by or on behalf of the appellant. Now, rereading the Upper Tribunal's transcript at page 80, it again is clear that the Upper Tribunal started the hearing, very well understood the scope of the appeal that was now being pursued. And this is in the core bundle. If we take it up at the bottom of page 88, this is still in the context of Mr. Howard trying to run an Article 32, Article 33 case. But you'll see the exchange at the top of 89, and Judge Raghavan saying, this is not an appeal against the way HMRC argued their case.
Sorry, this is this.
Forgive me, my lord, page 89.
89, yes.
Yes, very top, line 3, Judge Raghavan having a little discussion with Mr. Howard, saying this is not an appeal against the way HMRC argued their case, or could have argued it. For you to succeed in this appeal, you need to persuade us on the appeal grounds that you've been given permission for. The FTT erred in law. Your basic proposition is, it erred in law in not concluding on the basis of the FTDs that you must have lost the necessary possession and control of the goods to have made a supply in the UK or have a supply made on your behalf. So in respect of the case that had now been narrowed, the UT plainly understood what was being argued. And then turning into the judgment again at paragraphs 91 to 92, it's in the core, page 78. We have the conclusion there at 91. As we explained in dealing with ground 1, the FTT was fully entitled on the basis of the evidence before it to reach the view implicit in its conclusion that possession and control of the goods was not divested in France. The burden hadn't been discharged. Therefore, there is no concern over whether the FTT's findings were made with an incorrect legal test. No challenge is made against the FTT's assessment of the witness's credibility or to the other findings the FTT made. We've considered and set out our reasons above why it would not be reasonably open to a tribunal to conclude that the FTTs led to a conclusion that requisite possession and control have been divested by award, so that award's appeal must succeed. We've therefore set out relevant reasons why the FTTs do not have the result contended by award, and then the point at 92 that a lady picked up. So in short, and to the same essential point, UT was entirely satisfied, even after ADL had narrowed its case, relative to that pursued in the first tier. The appellant did not lose possession or control of its goods in France, and the appellant had relied upon the French transactional documents to claim that it had divested itself to those French companies with whom the appellant purported to do business, and found effectively that those companies were indeed stooges and had no means to acquire the goods, which, as it was found in the FTT and remade in the UT on the same basis, did not in fact ever acquire those goods, or had them at, or by implication, had them to do with them as they would if they were the owners. Now I want to turn to my learned friend's ground 1. It's in the core bundle, paragraph 4, page 18. Look at how he puts the one ground and what wanted.
Sorry, this is page...
Page 18 of the core, paragraph 4, and in particular 4.1.
18, sorry. Is this in the skeleton?
It's in the skeleton.
Could you give us the paragraph number? Sorry.
Yes, 4.1. Sorry,
4.1, right.
So it's said that the UT misunderstood HMRC's case as pleaded before the FTT. Specifically, the UT recorded, paragraph 50, that HMRC's pleaded case was that the customers were mere buffers, ... whose purpose was to give appearance of an in-bond transaction and thus facilitate the movement of the goods to the UK to be sold by or on behalf of award. Whereas such a plea had been expressly disavowed by HMRC in its response to an application for further and better particulars on May 31st, 2017. This was an error of law which affected the remainder of the decision, and it also prevented the UT from rectifying an error of law which the FTT had necessarily made. My lady, my lords, as I'll show you in detail, paragraph 50 does not in any way misunderstand HMRC's pleaded case. The statement in paragraph 50 is made in the wider context of considering whether the FTT erred in failing to find in effect that the appellant did indeed divest itself of possession and control of the goods. And the UT effectively accepted that those companies were mere buffers or conduits in the sense that, and this is really what's relevant to this ground 1 has put, in the sense that they never had the means to acquire the goods, never acquired the goods, which therefore at all material times remained within the ownership, possession and control of the appellant. And it was the fact that the appellant remained in possession and control of those goods that facilitated their return to the UK and their sale by and on behalf of ADL. That is all that the UT is saying in this paragraph 50, and we say they were quite right to so say. So on that analysis, we say the entirety of this ground 1 is based on a misreading of paragraph 50. The appellants underline the last part of the sentence and thus facilitate the movement of the goods to the UK to be sold by or on behalf of a ward. Now, can I ask you to turn to paragraph 31 of the appellant's skeleton? To show you how my learned friends have understood what the tribunal are there saying at paragraph 50. And they say, the UT made no reference to HMRC's response to the application of further and better particulars, notwithstanding that it was referred to in ADL's skeleton argument dated 17th February 2020 as lodged with the UT. Had the UT considered the FBP response, it would have understood that HMRC had disavowed any allegation that the goods had been smuggled into the UK by ADL or on its behalf, and also that HMRC had made clear that ADL's liability to that was based on the fact that it's received the proceeds of UK taxpayer supplies. So just pausing there, the words, it would have understood that HMRC had disavowed any allegation that the goods had been smuggled. Malone and friends are there reading the underlying line of paragraph 50 as the UT effectively saying facilitation was an allegation of smuggling. And it was saying nothing of the sort. It's obvious from yes, it's obvious from this paragraph 31 of the appellant's skeleton that it reads that line in the UT's judgment as understanding HMRC's case to include a positive case to the effect that the goods were smuggled by or on behalf of the appellant, a case that was indeed disavowed in the response to the request for further and better particulars. Now, if that was right, then there might be a narrow misstatement in that paragraph. But it's not right, because the UT well understood that HMRC were not running any such case. And in that regard, can we turn to paragraph 38 in the Upper Tribunal's decision, which is in the core bundle at page 65. Now, it's my learned friend's case that there is nothing, he put it this way, there's nothing in the UT's decision indicating that it paid any regard to the disavowal in the further and better particulars of what we were and were not pleading. But there are three such references. The first is 38, which is recording a submission that's being made by ADL, but one that records the disavowal that was made. While the above legal principles are uncontroversial, the parties disagree on how they apply to the facts of this case. We deal first with the appellant's argument that because HMRC conceded that no allegation was made that a ward or agents of a ward smuggled the goods into the UK, i.e. no positive case was being made, it necessarily followed that HMRC must have conceded that a ward had lost possession and control of the goods outside of the UK. So there, the UT was acknowledging the fact that such a disavowal had been made and was recording the use that the respondents were putting that disavowal to in pursuit of their case. And they noted that the submission went further to say, in light of this concession, it was not open to the FTT to make the finding. It did. Such a finding could only be made if a ward retained possession and control of the goods when they were in the UK. And then going to another paragraph you weren't taken to, 87, which is at page 77 of the core. you again see that they recognise the disavowal. Award raised a separate argument that the FTT failed to give reasons regarding the need to reconcile the implication that no possession and control was lost, with HMRC's disavowal that it was alleging Award had smuggled the goods. For the reasons explained in relation to ground 1 above, Award is wrong in its view of the relevant law. The FTT dealt with the relevant point sufficiently in our view, in the section of its decision dealing with burden of proof, when it recognised that the revenue were not making an allegation of fraud against Award, and therefore the position was as described in the passages it cited from Brady. Now the reference there to the discussion earlier in our decision is a reference in particular to paragraph 41. I'll come back to that in a moment because it's a crucial paragraph. But I said it was the disavowal was mentioned at 3 points, and the third, of course, is, which we've looked at already in the context of the preliminary issue, at paragraph 16. And again, it's about 7-8 lines down. Award argued that because HMRC had disavowed any allegation the goods were moved by way of inward diversion to the UK by or on behalf of Award, the movement of goods could only have been carried out on behalf of the customers. So they were absolutely fully aware of what we were not saying, namely that we were not making any positive allegation that a fraud was being perpetrated by ADL itself or by ADL's agents. We did not take on the burden of pleading or proving fraud against either ADL or any of its agents, because again this was a Brady case, this was a challenge to an assessment, and fell within the scope of the Brady principle, if I can call it that. Now that principle was re-articulated and applied by my Lord Justice Henderson in Genius Games, and that passage is set out in the Upper Tribunal, and noting that in traversing a challenge to a tax assessment, HMRC does not have to take upon itself the burden of pleading and proving fraud, even if the only explanation for why the taxpayer is subject to the charge to tax is because it's committed some fraud. So we say the UT clearly understood the disavowal that was made, and thus understood the scope of the pleading that we were pursuing, and the extent of the positive case that we were pursuing accordingly. It was well aware we were not saying that Awards was itself smuggling the goods, and that had never been part of the Commissioner's case. So turning back to the impugned paragraph 50 in the Tribunal's judgment, we say in circumstances where the UT plainly did understand HMRC's case and took account of the disavowal in the further and better particulars, it is clear that what is meant by facilitation in this paragraph was that the arrangements in bond with the purported French cash and carries enabled ADL to retain possession and control of the goods, such that the subsequent UK sales of those goods could be made by it or on its behalf. That's all the tribunal meant. That was the case it was squarely dealing with. And that reading is consistent with their understanding of HMR's case as reflected in paragraph 16, 38 and 87 of its judgment. Can I then take the court, please, to paragraph 38 of Malone & Friends' skeleton argument?
Have you got an eye to the time?
I do, and I
mean, do but we'll rise at 4:30 anyway.
Yes, my lord. I'm just thinking about whether I can get the FBB's point in before I sit down, and I think I probably can. My learned friend has gone through them. I'm not going to take you through them in detail.
All right. Well,
the key
let's see how we go.
So it's
That's right.
teed up by reference to paragraph 38 in Malone and Friends Skeleton. That's in the core at page 28. Sorry, 30.
Paragraph
38.
38.
Objectively analysed, HMRC's pleaded case was not that the goods were moved to the UK and sold on behalf of the appellant. Pausing there, objectively HMRC's case was that the goods were at all times retained by the appellant. They were sold by her on its behalf, and that's what the FTT and the UT found. And then in the second sentence of paragraph 38 it says, rather, HMRC's case with the appellant was that the appellant's supplier, or the purported French customer, diverted the alcoholic products to the UK. And this was not done as the appellant's agent. Now, we made no positive case that the French cash and carries or anyone else was actively responsible for the inward diversion of the goods. And as you now see, we didn't have to. Turning into the FPB's supplemental bundle, page 126. And as my lord and my lady have picked up, the key paragraphs, my learned friend relies on a few, but some of the key responses that he relies upon in support of the contention that we positively conceded that ADL and its agents did not engage in fraud or the facilitation of inward diversion. Are those responses at 4 and 5 on page 426? 4, we said...
Just go page...
I'm so sorry, 126.
126, yeah.
So the question is on 125, point 4, each of the purported French customers who are alleged to have diverted alcohol back into the UK under the cover of a single arc. The response was the alleged French customers are each of those who purported to purchase and take receipts of goods from the appellant, who never in fact paid for those goods or took delivery of them. Again, for the avoidance of doubt, HMRC does not contend that these French cash and carries were acting as agent of the appellant for purposes of effecting an inward diversion of those goods. And question 5, page 125, for the further avoidance of doubt, state whether any of those persons, firms or companies given in answer 19 above are alleged to have so acted as agent for the appellant, and if so, which ones? In the response at 126, HMRC does not allege, since it does not need to allege, that the appellant's alleged French cash and carry customers were the appellant's agents as regards the inward diversion of the goods to the UK. So taking those two responses together, HMRC, to my Lord Justice Henderson's point to my learned friend this morning, was seeking to make absolutely clear that it was not putting a positive case that ADL was engaged in this fraud, or that its agents were engaged in this fraud on its behalf. And yet constantly there is an elision made in the submissions by my learned friend, where on the one hand he acknowledges that we did not allege, i.e. put a positive case to the effect that ADL or its agents were engaged in inward diversion fraud, but that slips to a contention that we positively conceded that they weren't. And it's the latter that breaks the chain, which would allow them to say there has been divestment, and therefore whatever else happened in the UK, it didn't involve a taxable supply, because we no longer had ownership, possession, or control of those goods. Nothing in these responses amounts to a concession. And just before I sit down, my learned friend took you to various passages of Mr. Howard's skeleton below, contentions that he made in the Upper Tribunal, where he gives his take on what we say in these responses to the request for further and better particulars. But my lords, my lady, you can read them for yourselves. In a sense, what Mr. Howard takes from them is neither here nor there.
Well, I think that was being put to us on the basis that that was a case that had been put below.
Yes, and my lord put back to my learned friend quite rightly that the key passage, the key responses at page 126, were only taken by Mr. Howard in reply. So to say this was put front and centre, it is not correct. But in any event, to the extent that these are relied upon to say we had made a positive concession, that we accept that ADL and its agents were not in any way engaged in inward diversion fraud, is to misread these responses. That was never our case. My lord, is that a convenient moment, or do you have a question?
I just have a question, just something in at the start of what I'm treating as your skeleton argument rather than respondent's notice.
My lord, it is a skeleton.
It's a skeleton.
And it was written in slightly difficult circumstances, so I apologise for that.
No, don't worry at all. It's prompted simply by that. When application was made to this court for permission to appeal, did HMRC put in the usual 3-page statement of reasons why permission should not be given?
Can I come back to you on that?
Yes, and if you did, would you mind bringing copies for us in the morning, please?
Of course.
Thank you very much. Good, thank you very much indeed. Well, we'll carry on at 10:30 tomorrow morning.
All rise. Judge said 10:30 tomorrow, so we'll be opening from 10.
Are you locking up overnight? Oh, fantastic. Is it all right to leave things in here?
Well, I wouldn't be leaving,
Valuables.
no, things like your
Files that people aren't going to be interested in the files.
Kieran.